that my colleague, Representative McLane, stated about the baseball bat. When I read this, to me, this bill does not include baseball bats as deadly weapons. So I just want to make sure that's clear. I don't see how it can be construed that a baseball bat is a deadly weapon under this bill, because it's not specifically designed to cause death or serious physical injury. So I just want to differ with that conclusion.
Vice Chair McLane.
To reply, Madam Chair, to my good colleague, I want to say that it says any instrument, article, or substance specifically designed for and presently capable of causing death or serious physical injury. So anytime you have anything that's specifically designed for causing serious physical injury, and under the definition which under causing serious physical injury, for an example, car is deemed by the courts to be a dangerous instrumentality. So it is a lot broader than just simply saying, hey, what's traditionally designed, and in essence, in the way that we think of what's marketed as. Mm-hmm. But the fact is, the way that courts interpret this as, when you have something that in baseball bats have been used as instruments to cause severe physical injury, so that's not debatable. The question, what I hear from my good colleague, is that it's what's it designed for? But when you have something that's designed to deliver by the swinging of it with a physical force, using muscles in your shoulders and et cetera, swinging for, then all of a sudden you're within that realm of, is it excluded because its most common use is for the sport of baseball? What I'm saying is, based on the courts, don't know. So it's the looseness of this language which troubles me. If this was about firearms, then why didn't the drafters just simply say firearm? But by saying deadly weapon, this means that when a court issues this order and law enforcement now comes to the home of this person, this respondent, and removes firearms, clearly, but what else? Knives? All knives, right? So, right? Knives that are kitchen knives, knives that are, you can see how the looseness of this language is going to lead to difficult implementation. And that's why, now, I understand you said baseball bat, and of course I'm trying to push this a bit to show that there could be hypotheticals we could all agree, well, that's silly. However, if it could nonetheless be brought within the definition and argued with reasonableness, then it illustrates the difficulty of the definition, which is what I tried to do, maybe not as persuasive as I thought. But again, my point in this stuff is that there is looseness of it, and the process troubles me because, again, this goes beyond people have shown a risk of harm to themselves. And I agree with Representative Rayfield that clear and convincing evidence is a lot better than by preponderance. That's true. That's a better process. And I personally have confidence in our judiciary and how they apply the law, and I think we have pretty good people on the bench. So I agree with him on that. However, what this bill does is it says that if we believe you have a propensity, that A, you have a propensity for violence, and there is evidence you have violence towards this person, then we can strip you of possessing deadly weapons. Some of those weapons are actually protected by the Constitution of the state of Oregon in the United States. And before I can vote to do that, we have to have more evidence than this. And despite its cloaking, and no more perhaps compassionate person than a vet who is with PTSD, I nevertheless must be compelled to oppose. Thank you, Madam Chair.
Any further discussion?